Brij Bhushan Sharan Singh, a name that is making headlines once again, but this time around for all the wrong reasons. No defense there as of now. The Delhi police charge sheet is crystal clear, and sexual misconduct abroad is the big premise against this man who was once the World Federation Wrestling Federation of India's chief. Charge sheet lists multiple cases of sexual harassment abroad, specific incident, inappropriate sexual contact in Mongolia. Offence under section 354 IPC has been declared. Continuous pattern of harassment listed, and Brij Bhushan Sharan Singh denies the allegations but claims he is being framed. What an irony if it has to come to such a pass where the decision by the honorable courts, by the police findings, would anything be to go by. As of now, the charge sheet filed by Delhi police, 1082 pages charge sheet being filed, does not give much elbow room to Brij Bhushan Sharan Singh, obviously the man in the eye of the storm, after several wrestlers, athletes pressed charges and accused him of the misconduct. Delhi court on Tuesday had rather granted 2-day interim bail to Brij Bhushan Sharan Singh. He has been accused by 6 women wrestlers of sexual harassment, assault and stalking. And co-accused Vinod Tomar, former Assistant Secretary of WFI, which is Wrestling Federation of India, was also granted interim bail. But Thursday would be the time when it would be revisited, the case would be revisited. These two individuals who have not been arrested as of now, Delhi police says that they have not arrested them because they have been cooperating with the probe. And Brij Bhushan Sharan Singh, who is 66 years old, was taken to several places, several locations within India, within the country, where he made presence, and he had to corroborate, and the reenactment of the whole scenario was done. He was cross-questioned. Police had gone to his residence also in Uttar Pradesh, and there also his staff members and other help were probed. Obviously, a man of the moment there, Brij Bhushan Sharan Singh. Tomorrow would be the day when his bail plea would be heard. Interim bail, that procedural. Where do you see this case going, and how do you see this case in the court of law?
You see, this case, I've been terming this case as a very peculiar one because, had not there been any political angle involved, had the case been only purely a legal case, any other person there would have made similar charges, the course of action would have been entirely different. Now, what has happened from the very beginning, somehow this case took political turn, and the legal recourse which was available to the victims, they somehow chose not to opt for that. And because of that particular direction, things got messed up. Now you see, now the charge sheet has been filed. The usual process is the accused is arrested before the charge sheet is filed because custodial interrogation is required for the purpose of collecting evidence against that person.
Right.
Now, after the charge sheet is filed, whatever evidence was required to be collected is already part of charge sheet. So as far as the custodial interrogation of that accused person is concerned, that is no longer required. Even if you go by the charge sheet, you will find that more than 100 witnesses were examined. Approximately 15 on something corroborated what was the allegation, and rest of them somehow made statements which are not corroborative to the accusation which have been made by the victims. Now, in this situation, you see what is transpiring here is police has said in the charge sheet that because there are certain judgments from the Supreme Court which says that if the quantum of punishment which can be given for the charges labeled is less than 7 years or 7 years, the requirement of arrest is not that much required under law. So what police has said that because the charges for which allegation is made is within that limit and accused has been corroborating, has been complying with the notices which were issued by the police officers under section 41A of the CRPC, they chose not to arrest. But now, because in the charge sheet they have police has chosen to file the charge sheet in which they are supporting the allegations which were made by the victims. So there is no other option. And these offenses are non-bailable offenses. So accused person has no other option but to apply for bail. But in all probability, see, I should not make any future-looking statement, but there is a very good possibility that he may be discharged on bail.
Right. Ashish, stay with us. We are also joined by L.N. Rao, former DCP, Delhi. Welcome to the show, Mr. Rao. Always a pleasure to talk to you. Well, first things first, in your learned opinion, देर आए दुरुस्त आए वाली स्थिति तो नहीं हो रही है. FIR तो हुई, चार्जशीट भी आई, अब इंटरिम बेल मिल गई है. आशीष ने हमें बताया, he told us the grounds on how this interim bail and how the proceedings will happen tomorrow. But in your opinion, sir, the role of police and the role of judiciary, किस पर नजर रखी जाए?
Yes. Good afternoon to you and your viewers. And in addition to police investigation experience, and I'm also working as a legal professional for the last 10 years. In this case, I'm watching this matter, and I'm on several TVs on this case when it was during investigation. I think now there are durust aaye wali baat. It's not necessary because that investigation has been taken and undergone with a very legal procedure and all procedure of the procedure laid down by our CRPC and IPC, etc. Now that as the earlier my friend has stated that because the charges are non-bailable, then he has to apply for the bail, and accordingly the interim bail has been granted to him. And during investigation also, he joined investigation several times, and there are some contradiction in the statements of the witnesses. There are so many witnesses, and only about 15, 16 have corroborated the allegations. And since the allegations are of very old time, that is very period which is very long in years, so that that is not a case of POCSO or any other allegations like molestations also, which happened yesterday or day before yesterday. So in such type of cases, during investigation, it's the prerogative of the investigating officer whether to arrest the person or not to arrest the person, because this power of investigating officer cannot be taken away by any court or by any other person. That's why in this case the charge sheet has been filed without any arrest, without arrest of these accused persons. So now up to the court, honorable court, whether to see whether that permanent bail is granted to him or not. In all probabilities, this is a fit case for granting permanent bail, because in other previous cases there are traditions, there are precedents that when the police does not arrest a person and file a charge sheet, there are several judgments of Honorable Supreme Court and High Courts that in that case bail should be granted to the person when the trial starts in that case.
Right. Mr. Rao, stay with us. Ashish, let's rewind. Let's go back in yesterday's date. In your opinion, what was the basis for the court to grant them interim bail to Brij Bhushan and the other co-accused?
This is usual practice in the courts when the court is willing to entertain any matter on merit and not merit of the case, but as far as the merits of the bail are concerned in this particular matter, then usually interim protection is granted, because otherwise the whole case will become infructuous.
Right. So, Ashish, as Mr. Rao is saying that from his point of view, this case merits a proper bail to the accused and co-accused. Let's not, हम लोग ये तो नहीं करेंगे कि we would try and give the verdict before the Honorable Court decides that. But how do you see this case going? What are the benefits of doubt that Brij Bhushan Sharan Singh could have? Or do you believe the case from the wrestler's point of view is pretty strong?
You see, from the very beginning, the case proceeded on two different directions. One was that certain victims were of certain age, and then there was a particular victim who was underage at that point in time. So what happened in that particular case where the victim was underage, the POCSO was invited. I mean, the allegation sections of POCSO was invited. So the case was, legally speaking, was on a higher footing as far as the criminality is concerned. That was the main concern before this particular accused person. And
Right.
once the allegation under POCSO are gone, that becomes a very, legally speaking, very weak case because, as rightly pointed out by my learned friend, that the allegations pertain to years which are like 4 or 5 years back. So now, how to prove them, how to corroborate what is being stated is very difficult because the one particular thing is required to be kept in mind that our legal system, especially the criminal justice system, is based on the principle that the allegations must be proved beyond any reasonable doubt. Any
Right.
reasonable doubt is sufficient to get the accused acquitted. Now, in this particular case, if there is any smallest of contradiction as far as the contents of charge sheet are concerned, it will not only help this accused, but in longer run, we will find that this case will become a mockery of justice because when the allegations are that old, it becomes very difficult to prove. And as I said, slightest of contradiction is sufficient under our criminal justice system to get the accused acquitted.
Right.